Hi, I'm Guanhong from NCKU. Today I'm going to introduce about the general principles of civil code. Civil code is everywhere in our daily lives, from shopping at the convenience store to signing contracts. It is inseparable from civil law. Our civil law is divided into 5 parts: general principles, obligations, running room, family, and succession. Each of these parts represents a specific aspect of the law. First, the general principles section serves as a foundation of civil law. It covers fundamental principles and concepts such as legal acts, expression of intent, prescription, legal capacity, and capacity to act. These basic rules apply to all the sections of the civil code and form the basis for understanding and applying civil law. Second, the obligation section regulates the relationship between debtors and creditors, covering the creation, performance, modification, and termination of obligations. It includes general rules on contracts, torts, unjust enrichment, and management of affairs without mandate. Third, the running room section deals with property rights, including ownership, possession, usufruct, easement, and mortgages. It divides the rights individuals have over tangible and intangible assets and how these rights can be acquired, transferred, and extinguished. Fourth, the family law section governs family-related matters, such as marriage, divorce, parentage, adoption, and guardianship. It sets out the legal framework for family relationships and the rights and duties arising from them. Lastly, the succession section outlines the rules for inheritance, including intestate and testamentary succession, the administration of estates, and the rights and obligations of the heirs and legatees. It ensures the orderly transfer of a deceased person's assets to their successors. Today, we will introduce the general principles section, which serves as the foundation of civil law. It encompasses the fundamental elements such as legal acts and personal rights. Understanding the general principles provides a basic understanding of civil law thinking and is the first lesson in legal studies. For these videos, we will introduce the expression of intent in the general principles section and the related issues that arise from it. First, let's introduce what the expression of intent means. The expression of intent is the formal manifestation of various decisions and wishes we make in our daily lives. It consists of 2 components, intent and expression. The person making the expression of intent first has a specific intention that carries legal significance. This intention reflects their internal decision or desire to bring about a certain legal effect. For instance, when someone decides to enter into a contract, the intent is to create a binding agreement with another party. Once an intention is formed, the next step is to express the intention in an objective manner. This can be done through words, written statements, or even actions that clearly convey the intended legal effect to others. The combination of having the legal intention and its objective expression forms what we refer to as the expression of intent. Now, let's look at an example to better understand the concept of expression of intent. Imagine a person who intends to buy a cup of coffee. This intention represents the internal decision or desire to make a purchase, which is the first component of the expression of intent. Next, the person expresses this intention by approaching the barista and verbally requesting a cup of coffee. This act of communicating the intention is the second component, the expression. When these 2 components come together, the intention to buy a cup of coffee and the verbal expression of this intention, we have a complete expression of intent. In this case, the expression of intent is a formal communication of the desire to buy a cup of coffee, which the barista can then recognize and act upon. This example illustrates how our internal intentions, when expressed clearly, become legally significant actions that others can respond to, forming the basis of many legal transactions in daily lives. However, certain types of errors in the expression of intent might occur. So we are going to introduce what kind of errors might occur and how they are dealt with according to our civil code. For this topic, errors in the expression of intent mainly includes 4 types. First, the mistake in the expression of intent. Next, the fraudulent expression of intent. Third, the duress in expression of intent. Lastly, the fictitious in the expression of intent. When we talk about the mistake in the expression of intent, we refer to the situations where a decision has made based on a misunderstanding of certain facts or circumstances, leading to an incorrect expression of intent. This type of error can impact the validity of a contract because the true intention of the party was not correctly expressed. According to Article 88 of the Civil Code, if an expression of intent was made under a mistake regarding its contents, or if the true situation has been known and the expression would not have been made, the party may revoke the expression. However, this revocation is contingent on the condition that the mistake or ignorance was not due to the party's own fault. In essence, a mistake in the expression of intent occurs if one of the conditions are met. First, there is misunderstanding of certain facts or circumstances. Or second, if the actual situation had been known, the expression of intent would not have been made. Additionally, for the mistake to be considered valid for revocation, it must not be due to the fault of the person making the expression. This protects individuals who have made decisions based on the incorrect information that they could not have reasonably known or avoided. The presence of such a mistake may render a contract invalid or voidable because the contracts are founded on the clear and genuine intentions of the parties involved. If a significant mistake affects this foundation, the contract may not produce the intended legal effects, thereby safeguarding the rights of the party who made the decisions on the mistaken beliefs. To illustrate the concept of the mistake in the expression of intent, let's consider a simple example involving salt and sugar. Imagine you have a container that is not labeled, and you have mistakenly believed that it contains sugar when in fact it contains salt. Due to this misunderstanding, you decide to use what you think is sugar in recipe. If you had known the true content of the containers, you would not have used it. Thus, your intention to use sugar was based on the incorrect information. And the key point to decide the effectiveness here are: first, there was misunderstanding of certain facts, thinking the salt was sugar. Second, if you had known that actual situation that it was salt, you would not have made the same decision. Third, the mistake was not due to your own fault, as the container was not labeled. Therefore, it fits all the requirements of mistake in the expression of intent. So, according to Article 88, this kind of mistake allows you to revoke your expression of intent. Next, when we discuss the fraudulent in the expression of intent, we are referring to situations where one party deliberately used deceptive means to induce the other party to make an expression of intent. Fraudulent behavior directly impacts the authenticity and the validity of a contract because the deceived party was making decisions based on false information. This type of situation falls under the category of fraudulent of expression of intent. According to the Article 92 of the Civil Code, an expression of intent is procured by fraud can be revoked. There are 2 key points to understand here. First, if the expression of intent is procured by fraud, it can be revoked. Second, there are certain circumstances where the law, contracts, or trade customs impose the duty to inform. If one party remains silent despite having such a duty, this silence can be deemed as fraudulent. Additionally, Article 92 states that if the fraud was committed by a third party, the expression may only be revoked if the other party knew or should have known about the fraud. It also clarifies that the revocation of an expression of intent on the ground of the fraud cannot be used as a valid defense against a bona fide third party. To illustrate the concept of fraudulent expression of intent, let's consider an example involving the purchase of a diamond. Imagine the seller claims that the diamond they are selling is a natural diamond. If it turns out that the diamond is actually artificial, this constitutes fraud. Under these circumstances, the buyer has the right to revoke the expression of intent based on the fraudulent information provided by the seller. Alternatively, let's say the diamond is indeed natural, but is a blood diamond which is banned from trading due to its unethical origins. If the seller knows this but remains silent, despite having the duty to inform the buyer, this silence can also be considered fraudulent. In this case, the buyer could have revoked their expression of intent because the seller withheld critical information that would have affected the buyer's decision. Article 92 of the Civil Law states that the expression of intent procured by a fraud can be revoked. This protection ensures that the individuals are not bound by decisions made on the false pretenses or through deceitful means. It also underscores the importance of honesty and transparency in legal transactions. When we discuss the duress in the expression of intent, we are referring to situations where the decision is made under severe threat or pressure. These threats might have involved harm to one's personal safety, reputation, or property. The presence of duress undermines the voluntariness of the expression of intent, thereby affecting the legitimacy of the contract. If the expression of intent was made under the fear of duress, then it can be revoked to ensure individuals' freedom of expression. The protection is crucial because it ensures that the decisions made under coercion could not bind individuals to agreements that they did not freely and willingly enter into. According to Article 92 of the Civil Code, an expression of intent which is procured by fraud or by duress can be revoked by the expressor. If the fraud or duress was done by a third party, the expression can not only be revoked under the circumstances that the other party knew or might have known about the situation. Furthermore, the revocation of the expression of intent on the ground of fraud or duress cannot be used as a valid defense against a bona fide third party. To illustrate the concept of duress in the expression of intent, let's consider an example where someone is forced to sign a contract. Imagine a situation where an individual is threatened with harm unless they sign a contract. This threat would be to their personal safety, their family, or their property. The fear induced by these threats compels the individual to sign the contract, even though they would not have done this so voluntarily. In such case, the expression of intent signing the contract was procured by duress. According to Article 92 of the Civil Code, an expression of intent made under duress can be revoked. This means that the individual has the right to nullify the contract because their consent was not freely given. When we discuss the fictitious expression of intent, we refer to situations where one party makes the expression of intent in the contract, but without any real intention to follow through or fulfill the expressed intent. This behavior usually involves collusion with another party to achieve a hidden, deceptive purpose. According to Article 87 of the Civil Code, a fictitious expression of intent made in collusion with another party is void. However, this voidance cannot be used as a valid defense against a bona fide party, meaning someone who is acting in good faith and is unaware of the deception. The key points to understand here are: if the expression of intent is made fictitiously and in collusion with another party, it is void. Second, The avoidance cannot be a valid defense against any bona fide party who is acting in good faith. To further illustrate the concept of the fictitious expression of intent, let's consider an example involving the transfer of property to evade debt. Imagine a situation where an individual, the actual owner of the house, is facing significant debt. To prevent creditors from claiming the house to repay the debts, the owner colludes with another person to create a fictitious sale. On paper, it appears that the house has been sold to another person, but in reality, there is no intention to transfer the ownership. The actual intent is to shield the property from creditors. In this scenario, the actual owner creates an expression of intent to sell the house. The expression is made in collusion with another party who agrees to the fictitious sale. The true intent is not to transfer the ownership but to protect the house from being claimed by creditors. According to the Article 87 of the Civil Code, such a fictitious expression of intent is void. However, this voidance cannot be used as a valid defense against a bona fide third party, someone who acts in good faith and without knowledge of the site. In summary, we have discussed several key types of errors in the expression of intent and their legal implications. First, mistake in expression of intent. Second, the fraudulent in the expression of intent. Third, duress in expression of intent. Third, fictitious in expression of intent. The former three can revoke and the latter one will lead to void. Under these protections, all transactions are safeguarded, mitigating the risk posed by intentional deception or schemes. However, it is always important to protect ourselves by carefully considering contracts before signing. Therefore, deliberation is true path to safety in all our legal dealings. Thank you. Hope this video helps you have a basic concept about our general principles of civil code. Wish you have an excellent learning journey. Goodbye.